Morning, everyone. Thanks for joining. We were due to have both Hurmus and Fiona presenting today, but Fiona's had to be elsewhere. So Hurmus, bless her, is going to take you through navigating pregnancy and maternity rights and beyond. And I will pass you over to Hurmus.
Thank you, Verinda. Good morning, everybody. Yes, so Fiona is sunning herself in Spain at the moment. But we'll be here cracking on with pregnancy and maternity leave rights. The plan for the session is that we talk about all things pregnancy and maternity related as far as we can. I mean, an hour won't do it justice, but we are going to look at these issues in a case plan, sort of case study scenarios. So rather than me speaking at you for an hour and making it death by PowerPoint, the plan is that we'll try and make it as engaging as possible. Please use the Q&A and the chat function. I'm just thinking in terms of discussion, Tom, is the chat function, should we use the chat function or the Q&A function for sort of comments?
Yeah, if we use the chat function for comments, then we can keep that separate.
Yes. Okay. Yeah. So the Q&A is something that we can, if we have time at the end, we can look through. If not, we'll aim to get back to you on your queries. But yeah, please use the chat function so that we can get your comments. So without further ado, let's start with our first slide, please. So we're going to start with the world of IVF treatment. So basically, we're going to follow the story of Grace throughout this session. So Grace, she's a sales manager and she works at Inclusitech Solutions. She started 3 months ago, and we're basically going to follow her journey throughout this hour. So she starts off the process. She asks HR for time off for IVF treatment. The company doesn't have a standalone fertility policy. Should you allow Grace to have time off? So we've got a poll question there for you. I can see people already cracking on with that, which is great. So what do we think? Right, I think we've got everybody in. Yes, so we have 100% yes. Wow, brilliant. That's amazing. Well, I think that is the right answer. However, let's just expand on it a little bit more. I mean, why do we say that she should have time off? So IVF, I mean, we're all quite familiar with the concept of an employee being pregnant, requiring time off for antenatal appointments. And, you know, the process for that is fairly straightforward. You know, that employees are entitled to pay time off for antenatal appointments, to attend antenatal appointments. In relation to sort of fertility treatment and IVF, that's always been a bit of a question mark in the case law and the legislation, because there isn't actually a statutory right to time off for IVF treatment. That's not something that's kind of in the legal sort of box. However, it has been recognised over the years, obviously, as this sort of area has developed, that fertility treatment, getting fertility treatment can amount to sex discrimination if you're not, if you're not allowed to attend appointments to receive that treatment. So just to kind of recap for those who don't know, IVF treatment is the process where essentially there's a period of assessment and hormonal treatment is given to stimulate the production of mature ova for retrieval. And what that means is basically the ova is collected, or several ovas collected from the follicle, and that's called a follicular puncture. And once that follicular puncture happens, the fertilization of that ova is then inserted in vitro into the father's sperm. Implantation of one or more of those fertilized ova is then takes place into the uterus. So that's sort of the process. And as you can imagine, there are various sort of stages involved. You know, it's not just the actual implantation itself, but you've got the assessment, the hormonal treatment, the before and the after. And case will sort of initially develop to say, yes, actually time off should be given for the actual implantation process. And then as the years went on, that sort of further developed, where cases were actually saying you should look at the whole the process as a whole, the IVF process as a whole, and actually whether you're at the beginning of the process or at the latter stage of the process, because this is actually something that affects women in particular. Obviously, they go through the treatment process. They should be protected, and so there are risks of direct sex discrimination claims if an employee isn't allowed to take time off to attend these treatments. So well done, you're all on the right lines and absolutely right. I think that's the key factor to consider, is even if the strict letter of the law, as you'll see in a number of the cases we consider, even if the strict letter of the law doesn't give a statutory right, we're not just focused about statutory rights, we're also focused on discrimination, and making sure that a pregnant employee or new mothers or those on maternity leave do not suffer a detriment, unfavourable or less favourable treatment. So well done, thank you very much. Next slide, please, Tom. So pregnancy-related sickness. Here we have another poll question. So the IVF treatment is successful and Grace is now pregnant. She experiences excessive nausea and vomiting, known as HG, and she's not able to work and is signed off work for 2 weeks. So do we have to pay her? What do we think? I know these questions can sometimes be that they're always woolly on the facts. So, you might not want to say yes, you might want to say no, and you might be right there. Okay, what do we have? Okay, wonderful. So we have 72% that says yes, 28% that said no. So do we have to pay her? Well, actually, it's neither of those. The answer is it depends. It very, very, very much depends. And that might have been what you were thinking. So yeah, apologies for creating the confusion. But essentially, it's to get you thinking, really, is in, are there any specific rules that protect those that are off sick for pregnancy-related sicknesses? Well, actually, no, we're all about here, we're only about making sure that somebody who has a protected characteristic, i.e. in this case being pregnant, is not treated unfavourably or less favourably as a result of their pregnancy. So in this scenario, all that we really need to make sure is that we're paying the pregnant employee the same as what we would pay a non-pregnant employee, so that they are not disadvantaged. So this boils down to whatever the contractual entitlement is. If it's purely SSP, and provided she's been offered for 2 weeks, so as long as she ticks the mark in terms of she's absent for more than 3 days, she'll qualify for the SSP. If there's any contractual entitlement over and above that would apply to non-pregnant employees, then she would be entitled to get that. So there's no sort of rule that they need to be given full pay because they are off sick for a pregnancy-related reason. Thank you very much. Next question. Next slide, please. The Grace returns to work for a week and then is signed off for another 2 weeks, triggering stage 1 of the company's absence management procedure. Should you take Grace through an absence management process? What do we think? Yes or no? Okay. So we had quite a lot of participants. So 24% have said yes, we should take Grace through an absence management process, and 76% have said no, we shouldn't. So what do we think? Let's have some chats in the discussion. So why do we think yes? Why would you take Grace through an absence management process? Any thoughts? Or equally no, why do we think no? Do we have any brave participants? Right. Lovely. I'm getting some comments here. So we've got some comments here. It depends on her absence reasons, potential for discrimination claims. I would do the absence management to ensure support is provided on the assumption it's pregnancy related. No, in terms of setting attendance targets, but yes, maybe to occupational health. Pregnancy related absence can't be counted towards general sickness absence. Yes, exactly. So that's the answer I'm looking for. And yes, there are, as I say, it's woolly, isn't it? It's woolly in terms of the fact we don't know. She's off for another 2 weeks. We're assuming it's related to the HG and the vomiting and the sickness that's pregnancy related. And looking at it in that way, then yes, absolutely right, in terms of the comment that we must discount pregnancy related absences. The reason for that is because relying on pregnancy related absences in the normal way in a sort of staged absence management process would mean that, you know, there's unfavorable treatment. You know, she's ill and she's off sick because of the pregnancy, and if that triggers a process where her absences are being managed and she's getting a warning or some kind of action, then essentially that's unfavorable treatment and it's unlawful pregnancy and maternity discrimination. So on that basis, yes, the correct answer is there shouldn't be an absence management process in relation to absences that are caused by pregnancy-related sicknesses. And therefore, if there is going to be an absence management process, we need to be careful that any pregnancy-related absences are discounted when looking at the triggers. So normally what employers tend to do is mark pregnancy-related absences on a separate sheet or record. It's not in the usual, you know, kind of scoring system, doesn't feed into that system. And it's recorded separately, FYI sort of information. Obviously, some comments have also mentioned, yes, occupational health might be needed to work out sort of what support's needed, or if there's anything impacting in the workplace on her sickness. But aside from that, the absence management process should strictly adhere to absences that are non-pregnancy related. So well done, and thank you very much for your comments. Next slide, please. So Grace returns to work after a period of sickness-related absence. That's good, she's back. But she complains about the fumes coming from the company's warehouse next door. She highlights the fact that nobody has done a risk assessment for her. Okay, so risk assessments. Do we do them as a matter of course? Any comments, any thoughts? What do employers do? How do we go about risk assessments? Is there one that's undertaken regularly, just in general? Are risk assessments undertaken when an employee notifies your pregnancy? So yeah, we've got some lovely comments coming through. Thank you. So we've got, we do for all pregnant mothers, should be done as soon as the employer knows the person is pregnant. Would you do a maternity risk assessment for each trimester? Wow, okay, yeah. Thorough. 3 times during pregnancy. Throughout pregnancy, we're notified of pregnancy. Yeah, new expectant mothers. Brilliant. Pregnant and breastfeeding mum, brilliant. Yeah, absolutely. So refer to health and safety. Brilliant. So we've definitely, everybody's on the ball, which is great. So just to kind of outline the position then, obviously the starting point is always that all workplaces should have a general health and safety risk assessment undertaken for all of their staff, you know, as a matter of course, health and safety regs. In relation to women of childbearing age, the rules actually, it's regulation 16. And I really like the fact that actually everybody's on board with doing risk assessments during pregnancy, but actually the legal rules state that in terms of women of childbearing age, the risk assessment really only needs to be undertaken if the workplace itself could involve a substantial risk to health and safety of new or expectant mothers or their babies. So it's almost like this additional risk assessment, if you like, that should be done as a matter of course every year, should only include a bit about specific risks for women if the workplace itself is sort of hazardous in some way to women of childbearing age, or pregnant or new mothers. And typically you'll be looking at the processes, the working conditions, physical, chemical, biological agents, things like that, which may affect. So the first thing to note is that the general risk assessment that you have as a business should include that assessment if your workplace has those sorts of issues, as a matter of course. So there should be that first risk assessment anyway, that happens regularly. And the key thing there is that you shouldn't wait for an employer to become pregnant before doing that. And I think that's the bit that sometimes is missed. So yes, definitely have a risk assessment in relation to the pregnant individual once notified, tailored to that employee and their own medical recommendations and what have you. But equally, just bear in mind that if your workplace is one that may involve risk to pregnant mothers, expectant mothers, new mothers, that your initial risk assessment, the one that's the general one, should also include an assessment of those risks as well. Oh, I've got a message there. Only hosts and panelists can see the messages in the chat, so I don't get to see. Yeah, is there a way that everybody else can see the messages at all, Tom? Do you know, in the chat box?
Yeah, I've switched on now.
Ah, wonderful. Thank you. Thanks for that comment. So yeah, so the first point, as I say, is making sure, just checking in with your health and safety team, that the initial risk assessment carried out also has that sort of bit in it. And then secondly, yes, once notified of pregnancy, then what should then happen is go back, check that workplace risk assessment for any known risks, and then yes, undertake another one in relation to that pregnant employee to ensure that you're covering all bases. And what the law then says is that you must do all that's reasonable to remove or prevent the exposure to any significant risk that's found. So I don't know what various employers do. I mean, if there is a risk, obviously we're talking about fumes here. We don't know if they do cause a risk or they don't. But assuming that these fumes do involve a risk, then I suppose the question then becomes, what do we do with the employee? Any thoughts? What sort of things do employers, or have you been doing in your organisation? I mean, the sort of the main one. Yeah, exactly. Thank you. I think there's a bit of a delay, so I get no responses and loads. That's great. So yes, we've essentially things like looking at suitable alternatives, aren't we? So absolutely looking at ways in which we can remove those risks in her existing job if possible, but sometimes it just might not be possible. If there are, say, toxic fumes and you're required to attend work, for example, nearby, then no matter what duty you're given in the workplace, you'll still be exposed to the fumes. So for example, in that case, consideration might be given to home working if that's possible. If that's not possible, then you look at medical suspension. So what is medical suspension? Essentially, if there's no other alternative, we can't modify duties, we can't keep the employee doing sort of suitable work, then if we have no other alternative, then we must place the employee on fully paid suspension so that they are not penalised, essentially, from not being able to work. One thing that I thought was interesting in the cases I had to read yesterday when preparing for this webinar was that sometimes what employers tend to do is almost, with good intentions, proactively jump the gun and make assumptions about what an employee can and can't do. And there's this one case that I wanted to talk about because I thought it was interesting, where it was found that actually there was pregnancy discrimination in this case. So it's a fairly old case now, 2006 case, New Southern Railway and Quinn. And basically what happened in this case is that the manager suspended the employee on full pay but on the basis that they would never forgive themselves if something happened to the pregnant employee. So rather than acting on the basis of the risk assessment, they kind of based this suspension on their personal feelings that they'll never forgive themselves, and that was not an adequate basis for moving the moving the employee onto paid suspension. So I think it's just that reminder there that actually sometimes we might sort of make decisions based on what we think is right, but the key thing is to go back to the risk assessment in consultation with the employee in a collaborative way, to make sure that we're reaching the right result, because the employee may not agree, or the risk assessment might say something different. Because the idea, and let's not forget, it's not to eliminate all risk, that's just not possible, but actually it's a balancing act, and it's to be proportionate. Obviously also in conjunction with the employee, because sometimes the employee may not have any sort of appetite for risk, and it's sort of negotiating those sensitivities with the employee. But ultimately my view is consultation with the employee, checking the risk assessments, and looking at the recommendations of any medical advice is the way to go, absolutely, in terms of getting the right balance. So thank you very much for your comments. Next slide, please. So taking maternity leave. So this is the boring slide, which I'll probably skip in 2 minutes, but I'm going to test your knowledge now. So Grace is planning her maternity leave. Her expected week of childbirth is in 5 months' time. So what does she need to do in terms of notifying her employer of maternity, wanting to take, well, notifying them A, of her pregnancy, and B, of taking maternity leave? Do we know the timings, anybody? Yep. So we've got map B1, 50. Oh, brilliant. I think we're all absolutely spot on. 15th week before the expected week of childbirth. Yes, everybody's got the 15. I know there's a 15 somewhere. And that's absolutely right. So well done. So notification of pregnancy at least 15th week before the expected week of childbirth. Brilliant. And failure to notify, do we know what the consequences are if that doesn't happen? I think it's one of those questions which probably never come to fruition. Actually, we don't have any cases on it because people tend to take a fairly lenient, relaxed approach. But there have been situations where, for example, an employee is not aware that they're pregnant and they miss the deadlines. But yes, essentially what it means technically not to notify is that, yeah, you're not entitled to maternity leave and SMP and all the rest of it. So you technically lose out on the ability to qualify for those entitlements. Obviously, you'd still be entitled to not be discriminated against, but in terms of, you know, the right to compulsory maternity leave, OML, AML, and all of those, technically speaking, you wouldn't be entitled to them. Now, of course, that's not normally a road that we go down, because what tends to happen is if there is, for any reason, a failure to notify, there's normally a reason for it. And the law does say, you know, it's got to be, if there is a failure to notify within the correct time periods, but it's done as soon as reasonably practicable afterwards, then, you know, you should, again, that's seen as compliance. And again, there's a fairly flexible, wide interpretation of all of what that means. So ultimately, I think pragmatically, what we're looking at here is working with the employee again as to why they failed to notify. Have they notified you as soon as reasonably practicable? And generally speaking, there tend not to be any issues. So yes, I think you're all spot on there. Thank you very much. Next slide, please, Tom. Performance issues. So Grace's sales figures drop, and Ben, you will hear a lot from Ben actually, her line manager, says to HR, I know she's pregnant, but that is no excuse for poor performance. Ben asks HR if the company can sack Grace and says, my wife never had this much time off when she was pregnant. Delightful, Ben is. So can the company performance manage Grace? firstly? Got our lovely poll up there. Oh, it's close. Right, yes, very close. So 55% say yes, we can performance manage Grace. 45% say no, we can't. So I'd be very interested to hear your thoughts on all of this. So feel free to start commenting on the chat group, please. And I'm going to enlist Verinder as well. Verinder, what do you think?
Let me just unmute myself there. Gosh, not being a HR professional, I'm going to go with the percentage that said, yes, you can performance manage her.
Okay, yeah. So we've got a mixed view. I mean, it's hard, isn't it? So, her sales figures drop, and the kind of initial reaction would be, wouldn't it, that, well, actually, you're here to do a job. You're employed to make sales, and regardless of your situation, you've got to meet your targets. But actually, again, what's the law here to do? It's to protect unfavorable treatment. And actually, this is a question of, it depends. Yeah, exactly. Thank you, Natalie. Which we're getting here now, some comments, aren't we? So there isn't enough information, and that's exactly right. We don't have enough information, but it's just food for thought, isn't it? It depends. Why has her sales figures dropped? Is it because of her pregnancy related sickness or anything to do with her pregnancy, or is it for a completely unrelated reason? And I think that's absolutely right, that the reason for the poor performance is going to dictate what process we take with her. So and it's all about establishing that, and you might not get to that. So you might start the process, and during the investigation, or have a meeting with her, and it comes out that she's saying, well, it's because I've can't concentrate at work, or I've not been feeling very well, or because of my pregnancy X, Y, and Z, in which case, I think it's very important that you have that fact-finding process with her first before starting any formal performance management process. Because what we need to be very careful to avoid is, again, treating her less favourably or unfavourably because of a reason connected to her pregnancy. So it's all about the connections that we make. So I can completely understand why some people have said, yes, we should performance manage her. But equally, I think we haven't got enough information to assess on what basis and why. So absolutely, I think what we need to do is look at the reasons why. If we're not sure, and we might not be, because sometimes you'll have a conversation and it's still not clear, you think, well, is this, we're not medical experts. We might not know what causes a certain sickness, or she might say, I'm concentration, or I'm feeling tired, but is that connected to the pregnancy, or is that something else? We're not expected to know all of this. So the safest solution would be to potentially get occupational health involved, work out what's going on. Is there a reason connected to her pregnancy that's causing the performance issues? You're perfectly entitled to do that. In fact, that's better to do that rather than making any assumptions. Any thoughts on that? Let's have a look at the comments. I can see some comments here. So not enough information. Yeah. Fair, proportionate to the role, not direct result of pregnancy. Yeah. So that's it. It's ultimately making sure that we discount pregnancy-related sicknesses in our factoring, in our consideration process. Performance management is separate to absence management. Yes, so yeah, we're looking at her performance, but is the performance related to poor performance related to a pregnancy issue? Yes, and the manager, yes, lovely comment. The problem with Ben. So how do we deal with Ben's comments? What do we think? So we've got, I know she's pregnant, but that's no excuse for poor performance. So Ben's saying this to HR, and Ben's also says to HR, can we sack Grace? My wife never had this much time off. What do we think about Ben's comments? Yeah, what can be classed as sexist? Yes, I think we need to be very, very careful about throwaway comments that are made by particularly managers, to HR. You know, as HR managers, you know, being in the HR role, you know, we're the ones that sort of see the internal facing side, if you like, of line managers. We're kind of the link between line manager, employee, and it's very important to certainly shut these things down as soon as they come up. So him saying things like, no excuse for poor performance, I know she's pregnant. Well, I think that needs to be challenged there in terms of his assumptions, because ultimately the poor performance, the pregnancy may be an excuse for the poor performance. That's not correct, and absolutely it can be regarded as a sexist comment. My wife never had this much time off when she was pregnant. Again, it's that insensitivity in terms of is he not sort of, does he not believe that she's genuinely ill, thinks that she's, you know, sort of taking more time off than she needs to. So these comments indicate very clearly that Ben needs training. You know, he needs to learn more about pregnancy and maternity rights, equality, diversity and inclusion, and that would be a red flag. And, you know, if you've got a manager at this level, you know, at a manager level that's making these comments, there's clearly an indication that the business, you know, is in need of training in this regard. And actually, I'm going to come on to later, you know, what the risks for that sort of Ben type characters are for the business. Because ultimately, as an employer, we are liable for the acts of individuals in our business and what we can do to prevent that from happening. So potentially, we're looking at disciplinary for Ben. It could be an informal quiet word training. If we have more of a zero tolerance policy, it could be investigated in a disciplinary procedure. But ultimately, I think I would stress what I've observed is what tends to happen is these things either are sort of left, not dealt with, and then something bad happens. And actually, you know, at the moment, this might be a verbal conversation, but you'll be surprised how many written emails I've seen along these lines that then become disclosable in tribunal hearings. So it's very, very, very important that everybody's on the same page in terms of knowing rights and entitlements, and B, that they are trained on equality, diversity and inclusion, and that we have a zero tolerance policy when it comes to these sorts of comments, because no doubt if these are being said to HR, then they're being said elsewhere, or they're putting writing in text messages. And in this day and age where sort of we have WhatsApp being used in workplaces and other mediums, it's all too easy to sort of come up and find evidence of these sorts of things happening in a tribunal process. Thank you very much. Next slide, please. Bonuses. It's always a hot topic, bonuses. So Grace is now on maternity leave. She's made it. Inclusive Tech Solutions is due to pay a bonus to all employees. Ben does not want Grace to receive a bonus because he doesn't think she's earned it. Surprise, surprise. Is Grace entitled to be paid a bonus? So her contract says you shall be entitled to be paid a bonus from the bonus pool in relation to each financial year of the appointment on the terms of the scheme. So what do we think? Should she be paid? Yes or no? Yes. Okay. Brilliant. So we have 97% say yes, 3% say no. So right, a few things to talk about here then in terms of bonus and pay. So whilst on maternity leave, the first thing to point out is that, of course, we all know that pay in itself isn't maintained during maternity leave, that there's a special rule that actually you can provide for a different remuneration. So we have these statutory maternity pay rules. After 39 weeks, it's no pay. We know that ultimately, from a pay and remuneration perspective, the law does allow there to be a difference. However, that doesn't mean to say that that avoids any sort of discrimination issues. And the key thing to bear in mind here is that employees on maternity leave should be entitled, well, are entitled and should be paid for any bonuses that they have earned pre-maternity leave or post-maternity leave. So if, for example, the bonus year covers 12 months and they've been working for 3 of those months and off on maternity leave for the remainder, they are entitled to a pro rata entitlement to the 3 months worth of work that they've done, essentially. If we're talking about a bonus that's not related to sort of work done, and it's, say, for example, a team bonus, a company bonus, Christmas bonus, all those sorts of things, again, they should be prorated and paid out in the proportion that that individual has been in work. So there's not a rule that says they shouldn't be, or they should be paid the full amount, regardless of the fact that they've been on maternity leave. But equally, they shouldn't be given no pay just because they're out of the business for some of the time. It's all about making sure that they get a pro rata entitlement. Yeah, if you offer more, I've just seen a comment that says we treat the same as if they're working. Brilliant, you know, in terms of offering more. The one thing I would just highlight about that is making sure that you're not exposing yourself to claims from men, because of course there have been some cases, and I'm going to talk about one a little bit later on, where, you know, inflating, you know, helping out individuals or women on maternity leave or what have you, can sometimes give rise, it can work the other way. And men might say they've been treated less favourably when comparing themselves to a woman. So if you've got a man that's, you know, for example, been out of the business because he's been, say, on sick leave, but they don't get the bonus and the woman does, there could be an argument there that actually, well, I've been treated differently. So that's just something to bear in mind. But overall, I'd say the key thing here is proportionality, looking at the targets, prorating if that works, and yes, yeah, obviously just taking a consistent approach. Yeah, so brilliant. I can see you do that. Fantastic. Thank you very much. Next question, please. Annual leave, again, hot topic here. So during her time on maternity leave, Grace asked to be paid for some holiday for a trip to Spain. She's told that she cannot be paid as it would break her maternity leave. So that's right, nothing wrong with that. You can't take holiday during maternity leave because that'll bring your maternity leave to an end. So Grace then asked to take her holiday when she returns, 2 days holiday per week for 12 weeks. She's told that the company is understaffed, it would be disruptive to grant the holiday request. It is refused for genuine business reasons. Okay, so can Grace carry over the holiday, first question, into the following leave year? We've got a nice 100% yes, and that is right. Yep, so case law has established that. You can. So Grace can use up, she'll accrue her holiday in the normal way during her maternity leave. She can either take some of that sort of before she returns to work or after she returns to work. So that's absolutely right. Is it reasonable for the company to refuse the 2 days per week holiday request? This is a juicy one, so I do want some comments, please, here. On the poll, we've got 84% yes, it's reasonable. 16% say no, it's not reasonable to refuse. But let's get some meat on the bones there. What are we thinking? Reasonable to refuse or not? Why? What do you think? Yeah, so yeah, we've got, you can refuse if for business needs. Oh, yeah, it's all coming in now, hang on. It's unlikely to be refused, reasonable if they can genuinely argue it's for business reasons, and offer alternatives. Offer alternatives is important. Genuine business reason, it's reasonable. Any, yeah, genuine. Yeah, so this thing about genuine business reason, I think we need to be careful. We need to be very careful, because what we're looking at here is what risk are we trying to avoid? Firstly, let's get back to the law. So refusing the leave could potentially be indirect sex discrimination. That's kind of the red flag risk. So we've got a policy of not allowing holidays to be taken 2 days per week, for example. That's the provision, criterion, or practice. Does that negatively or disproportionately affect women because they have the burden of childcare and they have childcare responsibilities? That's essentially the question that will be asked in a tribunal. You know, are women disproportionately affected by having this sort of provision, rule, or criteria? Now, I know in this case it says we're understaffed and that's why it will be disruptive to the business. So that's given as a reason for the refusal. And we're saying that there's a genuine, you know, it's a genuine business reason. But when it comes to indirect discrimination, the only way that that can be lawful is if it's objectively justified, which means we need to have a legitimate business reason. And in this case, it sounds like we do have a legitimate business reason. We're saying that actually we're understaffed, but that reason has to be a proportionate means of achieving a legitimate aim. So it's got to be proportionate in the circumstances. So it's got to be something where we can say there are no other alternatives of dealing with this request. There is no other way that we can deal with the situation that's less discriminatory. So ultimately, I think what you're right in that there's, again, there is a genuine business reason, but we need to be mindful and careful of the fact that it's got to be proportionate. And what that means is if there is an alternative that's less disruptive for the employee, then we should look at that. So she might then say, actually, all right, I'll do 1 day a week. And we should consider that. That might be a less discriminatory way of dealing with our legitimate aim. And again, we need to test that we're saying why we're saying we're understaffed. You know, is that really sufficient? So yes, it's a genuine reason, but if we put it to test, would it still be workable? Wouldn't it be workable? Have we tried it out before? These are sorts of the considerations we'll be expected as the employer to answer. You know, how do you know that you won't be able to manage? You know, people go on holiday, you know, and you manage. Is there somebody else that could be put to work overtime, for example, or can you request a job share? So it's all about proportionality in these sorts of cases. And I just want to temper the genuine business reason with it's not a blanket sort of reason that we can kind of crack on and pursue what we're doing. I think it's important to remember that proportionality is also something to bear in mind. So just looking at the comments, yeah, annual leave not need to be used. It will, at least having grace at work part-time. So that's right, that's a good point as well, that actually what we're saying is this accrued holiday needs to be used at some point. So actually a blanket refusal could potentially be unjustified because, well, it needs to be used at some point. Are we saying, well, you can't use it in this fashion, but you can use it in another fashion, or take it in a block in 2 weeks' time, or what have you? So it's just being mindful of not having a blanket refusal. I think that's the key takeaway and the advice that I give to clients. We had a very similar case, actually it's in tribunal at the moment, where an employee, she sort of requested this pattern of, it's almost like wanting to work part-time, isn't it, for a period of time after you come back from maternity leave. So you want 2 or 3 days holiday, you're a full-timer, but you use that to supplement, or you know, you work 3 or 4 days, you build up your full-time hours basically for a couple of weeks. It's not been to hearing yet, but our advice there has been, yes, you need to look at exactly the things that we've talked about here in terms of Why does she want to take it in this fashion as well? Is it because she needs to arrange childcare? Is it because she just fancies to take the extra time off, spend time with her child? Because obviously that's also different. Ultimately, we're about avoiding detriment. It's not about spending more time with your child necessarily. It's about childcare. So it's looking into all of those issues. And actually, you know, our advice was, you need to delve into, you can't blanketly refuse. You must look into the business reasons and be able to evidence those business reasons and show that you've considered alternatives. So thank you very much for that. Next slide, please. Redundancy. Yes, tricky topic of redundancy. So there is a need to reduce costs. A restructure is due to take place and only 2 of the 3 sales managers are needed. So we've got Grace on maternity leave, 2 other sales managers. What factors need to be considered during the redundancy process? So just thinking about selection and scoring firstly, any thoughts? We've got somebody on maternity leave. What considerations would we have in mind? So yeah, we've got engaged with Grace during consultation. Yeah, that's a very important one. Do not ignore our employees on maternity leave. Do not forget about them. Very important. So it's always making sure that before they go on leave, we have procedures in place, mechanisms in place to keep reasonable contact with them. So a personal email address, or if it's a telephone or what have you. And using that as a means to communicate with them. They should be sent all the same letters as those others who are at risk of redundancy. Yes, non-discriminatory selection criteria, very important, thank you. In terms of that, we need to think about the factors that we use in our scoring. So if, you know, we're looking at absences, we have to make sure that we discount the pregnancy-related absences. If we're looking at absence record, we have to discount the maternity leave. In terms of performance, we've got to be careful that we're looking at performance that's sort of not tainted or influenced by any performance-related issues as a result of pregnancy or maternity leave. Do we inflate scores? What do we think about that? So say there's a criteria that, you know, we know that it's been impacted by pregnancy or maternity, do we just give them full marks? Any thoughts? Well, we did have a case on that actually, and the answer is no. We shouldn't be inflating redundancy scores. We shouldn't, in terms of what we need to be very careful of, and I've seen some comments here of the distinction between a fair selection process and then the additional protection that's given once redundancy selection has taken place. So during the redundancy selection process, those on maternity leave or pregnant, they do not get any enhanced protection there. All you need to be focused on is making sure they're on an even playing field. So they shouldn't be given full marks if they can't be given full marks. If there's a criteria where they would be disadvantaged, it's probably best either to remove that criteria altogether or look at a point in time where they weren't disadvantaged. So there was a case on this where a male at Evershed's law firm brought a claim of direct sex discrimination because he was a male, and they were sort of looking at lockup as a criteria, which is basically the time between a lawyer completing a piece of work and then receiving the fees for it. It's, you know, in our lawyer world, something that's quite important. And actually, that was one of the selection criteria. And more points were awarded for a quick turnaround. So if you do the work and get the fees in quickly, you get a high point. The chap, he received a certain point. I think he got 0.5 points, which was the lowest possible score. The employee on maternity leave, Evershed, decided to award her the highest possible score, even though, you know, there was no sort of basis for that because she wasn't she was absent in the time period that this was being assessed. But they said, right, because she's on maternity leave, we'll give her full marks. But actually, of course, what that meant was that he was treated less, the male was treated less favourably because she was given the top marks, whereas he was actually assessed. So the tribunal upheld his discrimination case and said that what they should have done is looked back at the point in time. They should have used a time period where she was in work that they could measure performance, or the alternative would have been not to have used that as a factor altogether. So yes, everyone should be treated the same. And it's about evening the playing field, not giving an advantage in the playing field when it comes to selection criteria. In terms of the extra protection that's given, that the actual positive discrimination that I can see that's been mentioned in the comments, that relates to the process after selection. So once the selection has happened and an individual has been identified as being sort of at risk of redundancy. So you've gone through the selection and say that the person on maternity leave or that's pregnant has the lowest score. The laws have recently been enhanced to say that anybody that's pregnant on maternity leave or when they come back sort of 18 months after childbirth, throughout that whole period, they get first dibs on any suitable alternative role. So if they've already been identified as at risk of redundancy, they've been selected for redundancy. If there are any suitable alternative roles, they must be offered those roles. So what mustn't happen is they mustn't be put through an interview process for a suitable role. So that is the positive, if you like, the thing that is the positive discrimination towards women. That's sort of lawful, if you like. So we've got an example in the Human Rights Code about this. So, for example, a company decides to combine their head office and regional teams and create a centre of excellence in Manchester. New structures drawn up. And if there are lots of different posts, what the guide says is that those unsuccessful at interview, obviously will be made redundant. At the time this is implemented, one member of the team is on maternity leave. She has priority right to be offered the suitable alternative vacancy in the new organisation without having to go through a competitive interview process. And yes, exactly. So this applies across the board to sort of adoption, shared parental leave, what have you. So it's very important that we bear that in mind when it comes to offers of suitable alternative employment. Next slide, please, Tom. Keeping in touch days. So Grace finds out that Tech Solutions hosted a Christmas social and she wasn't invited. Grace speaks to Ben, who says, you don't want to be out drinking now that you're a mum. So should the company have invited Grace to the party? 100% yes, absolutely right. So this is all about making sure that employees on maternity leave are kept up to date and informed of social events, any business updates, anything to do with vacancies, opportunities, job opportunities. So it's very, very important that we do have a medium of communication with employees, that we don't just rely on them checking their work emails. I've had that, some clients say, oh, well, they can check or they can go on the intranet. It's very important that they have their own supply of emails. So normally what I suggest is that employees set up, that these automated emails go to the personal email address, obviously informing the employee that that's the case and making sure that they're happy. But we do have an obligation to keep them updated with these sorts of things. What claims might flow from this situation? So discrimination obviously being excluded. Ben's comments, what do we think? Harassment, I'd say. Although you can't bring a claim for pregnancy and maternity harassment, you can for sex, on the basis of sex, and it's likely that this sort of comment would fall within that camp. So again, re-emphasising the training for Ben, I'd say. Next slide, please, Tom. Flexible working requests. So Grace is due to return to work in a few weeks and emails HR with a flexible working request. Ben says that they have made another sales manager redundant. The team is now very pressed and he needs her to work full time. So can you refuse the request? Yes or no? So we've got majority yes, 85% says yes, 15% says no. In terms of the request, I mean, she's saying, I mean, I've not read it out in detail, but the request is there. It does say she wants to work 4 days a week, working 50% from home. Again, I think this is a question of it depends. So, you know, vague poll there. It does depend, but I think we need to carefully analyse it. I think just saying we're pressed and you need to work full time doesn't cut the mark. Having, you know, it's about really getting your managers to question and think about why they're saying no. Again, I had a similar case with a sales manager where they said, oh, sales managers can't work. They can't work part-time. Sales managers have to work full-time because of the nature of their role. But when you actually challenge that, and I said, well, where's your evidence for that? Has it happened before and it's not worked out? No. On what basis do you say that? Well, they've got to sort of have lots of contact with customers and travel and see customers. But when we analysed it, actually, they were doing a lot of admin days where they weren't meeting customers, and actually there were ways around that. So it's really about challenging it. A manager will say what's most convenient to them, of course, to keep the business running. They'll say, no, it's just not possible. But for us, it's about challenging that, because that's what a tribunal will do. And it's about looking at, can it be workable? Trial periods are important. If you can't, you know, if you can't accommodate the full request, I'd say try and accommodate an alternative version of the request, and offer it as a trial to see if it works or it doesn't. But it's all about backing up your decision with evidence. So if you might have a genuine business reason, but it's got to be supported by evidence. And if it isn't, it will be challenged. So just bear that in mind. Thank you. Next question. Next slide. Breastfeeding. I'm just conscious of time as well, so I think I'll just talk through this. Grace returns to work and is still breastfeeding her baby. She asks Ben where she can express and store her milk, to which he responds, can't you do it in the toilets? Grace complains to HR, and Ben says, been telling tales again, good luck with this year's bonus. So Ben's not doing very well, is he? So facilities, what facilities should you have in place to accommodate breastfeeding at work? Well, the first thing to know is that there aren't any particular rules requiring breastfeeding facilities at work. What is required is a place for breastfeeding mothers to be able to rest. Toilets are not deemed to be suitable. So in response to this question, no, she can't do it in the toilets. And there was a case about this actually where a mother had to express in the toilets and during her lunch break, and she tried to express in the car whilst eating her lunch, and obviously it was all discriminatory, and it was treated, you know, regarded as harassment. So I think what's important to remember here is that there is a place that's suitably private and warm that a breastfeeding mother can use, and suitable facilities for storing the milk, so a refrigerator of some kind. In terms of, again, the comment, you know, being telling tales again, I mean, clearly there's a whole host of things here. Ben, you know, we've got him for harassment, direct sex discrimination, indirect victimization, you know, we've got it all here. So certainly I think what we need to be careful of is sort of comments like this. Again, you know, she's raised an issue and he's saying, you know, that she's going to be penalized as a result of you know, making those comments. So that would be a clear case of victimization. Thank you. Next slide. So tribunal claims, just lastly, I know we're conscious of time, so you might need to drop off, but just to kind of, again, bring to our minds here that actually, you know, Grace has had a very bad ordeal with Ben, you know, so she brings a tribunal claim. And the question is, can Ben be personally liable? Does the company have a defence? So it's just to make that final point, really, that yes, Ben can be held personally liable. So those that commit acts of discrimination can be faced with tribunal claims themselves. In terms of the company's position, in order to protect yourself as a business, you must take all reasonable steps to prevent harassment, because you are liable as a business for the acts of your employees. So the question here then becomes, have you done enough to prevent, to be able to defend that claim, to say that I took all reasonable steps to prevent the discrimination from happening? And there was a case a couple of years back, the Galen case, which made, it was a very stark judgment actually, and it said that, you know, you can have policies in place and you can deliver training every so often, but that doesn't mean to say that you'll be able to defend a claim, because it's about whether the training has become stale, whether managers, even if you've got training, if you've got somebody like Ben still making these comments, it means your training hasn't been effective. So it's about being reactive to the situation and being alive to people really not taking on what you've been training them on. So very important to have regular, frequent training, and then keep a watching eye on any issues that still arise and how you might go about tackling those when they happen. In terms of liability, obviously we know that discrimination claims are, you know, compensation is uncapped for loss of earnings. We have an injury to feelings award, and so therefore it's very, very important that we as a business try and protect ourselves in terms of defending these sorts of claims. Thank you. Next slide. I know it was just to say any questions, but I appreciate that we've kind of run out of time now. So what I would say is thank you very much for all your cooperation. Feel free to put any questions in the Q&A and we'll come back to you on those questions. I hope you found it useful, and again, thank you very much for your time.